Criminal law is a human construct designed to regulate the behavior of individuals within a society. It can be viewed as a tool of social control, while the criminal justice system serves to enforce that law and apply it fairly. However, critical theorists often argue that criminal law tends to serve the interests of certain groups at the expense of others. With this perspective in mind, we now turn to the origins of American criminal law. Formal, written laws are a relatively recent development in human history, first appearing around 5,000 years ago alongside the emergence of institutions such as property, marriage, and government. The earliest known written laws, dating to approximately 3000 B.C., were discovered on clay tablets among the ruins of Ur, a city-state of ancient Sumer. One of the most famous early legal figures was Hammurabi, the best-known king of Babylonia, who ruled from 1792 to 1750 B.C. He is renowned for establishing the first great code of laws. All ancient nation-states and civilizations developed formal legal codes. Such codes were established by the Egyptians, Assyrians, Hebrews, Persians, Indians, Chinese, Greeks, and Romans. The criminal law of the United States is largely derived from English law. Prior to the Norman conquest of 1066, England was inhabited by Anglo-Saxon tribes who governed themselves through customary practices. When William I of Normandy conquered England and declared himself king, he claimed all land and land-based rights, including the authority to administer justice, as belonging to the crown. In the early 12th century, the institution of the Eyre, or circuit court, was introduced. These traveling judges, acting on behalf of the king, inspected the operations of local courts within their assigned regions. Forfeiture was common during this period. The property of individuals who violated the king's peace could be seized, and it was the responsibility of circuit judges to ensure the king received a portion of these forfeitures. Originally, the term felony referred to an offense severe enough to sever the bond between a landowner and his lord, resulting in the forfeiture of the land to the lord. Over time, Norman rulers expanded the use of forfeiture to include less serious offenses such as trespassing. The Norman kings of England worked hard to centralize their power. However, their success was limited. In 1215, a group of powerful landowning nobles, frustrated by King John's heavy taxes and authoritarian rule, rose in rebellion. They forced him to sign the Magna Carta, or Great Charter, a document designed to resolve the conflict by placing limits on the king's authority. While the Magna Carta did little to help ordinary people at the time, it marked a turning point in English governance. From that moment on, monarchs were expected to rule according to established laws and customs rather than their personal desires. Justice, too, was meant to be administered fairly and consistently by the king or queen and their judges. The Magna Carta laid the foundation for the principle of the rule of law and introduced the earliest form of what would later become known as due process. Although American law is rooted in English traditions, the first form of criminal law and justice practiced on the land that would become the United States came from Native American societies. Among them, the Cherokee Nation had a distinct legal system long before European contact. Cherokee law was passed down orally through generations and was believed to be divinely inspired. In this system, nearly all crime, except for murder, could be forgiven. At its core, Cherokee criminal law aimed to restore social harmony and consensus, resembling what we now refer to as restorative justice. Traditional Cherokee law categorized crimes into 4 general types, each overseen by a different authority. Offenses against the community were addressed by a tribal group functioning similarly to a court. Murder, however, was treated as a personal offense rather than a public one and did not go to trial. Instead, justice was carried out through blood revenge, typically administered by the eldest male relative from the victim's generation and clan. This legal structure remained largely intact until around 1710, when the Cherokee people began expanding trade with white settlers in what is now Charleston, South Carolina. Over the next century, as white colonial influence grew stronger, the Cherokee gradually adapted, incorporating elements of the colonists' legal system into their own. In the United States, criminal laws, or criminal statutes, are almost entirely a product of constitutional authority and the legislative bodies that enact them. They also are influenced by common law or case law interpretation and by administrative or regulatory agency decisions. Constitutions play a vital role in criminal law by establishing legislative bodies with the power to create laws, including criminal laws. These constitutions are crucial because they define the limits of what can be considered a crime. Criminal laws are created by these legislative bodies. At the federal level, criminal laws are passed by Congress, while state legislatures create laws at the state level. Local governments, such as city councils, make laws called ordinances, which apply only within their specific jurisdiction. While statutes and ordinances apply in their respective areas, another important source of law is common law, also known as case law. Common law develops from the decisions made by trial and appellate court judges. Each decision can set a precedent, meaning it can be used to guide future decisions in similar cases. This principle is known as stare decisis. Common law was a key source of criminal law in colonial America, but today it plays a smaller role. Notably, there is no federal common law, although it remains important in interpreting statutes. Another significant source of law comes from administrative or regulatory agencies. These agencies are created through statutes passed by legislative bodies. They develop rules, supervise activities within their area of responsibility, and issue decisions that have the force of law. Though federal and state criminal statutes operate independently of one another, and much of the enforcement happens at the state level, there is a crucial interdependency between various sources of legal authority. Each source of law works together to shape the overall criminal justice system. This is a content-heavy section. Once again, Professor Rees encourages you to read your book.